Well, Justice Sotomayor, let me say this, which is to say, you're right in the first point to say that it's the states that do it, which makes it different right there. But it's also...
Well, that goes back to the substantive due process question. Is this a Lochner-era argument that only the states can do this, even though it affects commerce? Cars indisputably affect commerce. So are you arguing that because the states have done it all along, the federal government is no longer permitted to legislate in this area?
No, I think you might make a different argument about cars than you would make about health insurance, unless you tried to say that,
health insurance, I've never gotten into an accident, thankfully, and I hope never. The vast majority of people have never gotten into an accident where they've injured others. Yet we pay for it dutifully every year on the possibility that at some point we might get into that accident.
But Justice Sotomayor, what I think is different is there's lots of people in Manhattan, for example, that don't have car insurance because they don't have cars. And so they have the option of withdrawing from that market. It's not a direct imposition from the government. So even the car market is different from this market where there's no way to get outside of the regulatory web. And that's, I think, one of the real problems with this because, we take as a given...
But the given is that virtually everyone, absent some intervention from above, meaning that someone's life will be cut short in a fatal way, virtually everyone will use health care.
At some point, that's right, but all sorts of people will not, say, use health care in the next year, which is the relevant period for the insurance.
But you think you can better than the actuaries or better than the members of Congress who worked on it look at the 40 million people who are not insured and say which ones next year will or will not use, say, emergency care? Can you do that any better than if we knew that 40 million people were suffering, about to suffer, a contagious disease, and only 10 million would get sick?
Of course not.
We don't know which.
Of course not, Justice Breyer, but the point is that once Congress decides it's going to regulate extant commerce, it is going to get all sorts of latitude to make the right judgments about actuarial predictions, which actuarial to rely on, which one not to rely on. The question that's a proper question for this Court, though, is whether or not, for the first time ever in our history, Congress also has the power to compel people into commerce, because it turns out that would be a very efficient thing for purposes of Congress's optimal regulation of that market.
But, Mr. Clement, this goes back to the Chief Justice's question, but of course the theory behind not just the government's case, but the theory behind this law is that people are in this market right now, and they're in this market because people do get sick, and because when people get sick, we provide them with care without making them pay. And it would be different, if you were up here saying, I represent a class of Christian Scientists, then you might be able to say, look, why are they bothering me? But absent that, you're in this market. You're an economic actor.
Well, Justice Kagan, once again, it depends on which market we're talking about. If we're talking about the health care insurance market...
Well, we're talking about the health insurance market, which is designed to access the health care market.
And with respect to the health insurance market that's designed to have payment in the health care market, everybody's not in the market. And that's the premise of the statute. And that's the problem Congress is trying to solve. And if it tried to solve it through incentives, we wouldn't be here. But it's trying to solve it in a way that nobody's ever tried to solve an economic problem before, which is saying, it would be so much more efficient if you were just in this market.
But they're in the market in the sense that they're creating a risk that the market must account for.
Well, Justice Kennedy, I don't think that's right, certainly in any way that distinguishes this from any other context. When I'm sitting in my house deciding I'm not going to buy a car, I am causing the labor market in Detroit to go south. I am causing maybe somebody to lose their job and for everybody to have to pay for it under welfare. So the cost shifting that the government tries to uniquely associate with this market, it's everywhere. And even more to the point, the rationale that they think ultimately supports this legislation, that, look, it's an economic decision. Once you make the economic decision, we aggregate the decision. There's your substantial effect on commerce. That argument works here. It works in every single industry.
Of course, we do know that there are a few people more in New York City than there are in Wyoming who never will buy a car. But we also know here, and we don't like to admit it, that because we are human beings, we all suffer from the risk of getting sick And we also all know that we'll get seriously sick. And we also know that we can't predict when. And we also know that when we do, there will be our fellow taxpayers through the federal government who will pay for this. If we do not buy insurance, we will pay nothing. And that happens with a large number of people in this group of 40 million, none of whom can be picked out in advance. Now, that's quite different from the car situation, and it's different in only this respect. It shows there is a national problem, and it shows there is a national problem that involves money, cost, insurance. So if Congress could do this, should there be a disease that strikes the United States, and they want everyone inoculated, even though 10 million will be hurt, it's hard for me to decide why that isn't interstate commerce, even more so, where we know it affects everybody.
Well, Justice Breyer, there are other markets that affect everyone: transportation, food, burial services, though we don't like to talk about that either. There also are situations where there are many economic effects from somebody's failure to purchase a product. And if I could talk about the difference between the health insurance market and the health care market, I mean, ultimately, I don't want you to leave here with the impression that anything turns on that. Because if the government decided tomorrow that they've come up with some private companies come up with a great new wonder drug that would be great for everybody to take, it would have huge health benefits for everybody. And by the way, also, if everybody had to buy it, it would facilitate economies of scale, and the production would be great, and the price would be cheaper, and force everybody in the healthcare market, the actual healthcare market, to buy the wonder drug. I'd be up here making the same argument. I'd be saying that's not a power that's within the commerce power of the federal government. It is something much greater, and it would have been much more controversial. That's one of the important things. In Federalist 45, Madison says the commerce power, that's a new power, but it's not one anyone has any apprehension about. The reason they didn't have any apprehension about it is because it's a power that only operated once people were already in commerce. You see that from the text of the clause. The first kind of commerce Congress gets to regulate is commerce with foreign nations. Did anybody think the fledgling republic had the power to compel some other nation into commerce with us? Of course not. And in the same way, I think if the framers had understood the commerce power to include the power to compel people to engage in commerce.
Well, once again, though, who's in commerce and when are they in commerce? If the effect of all these uninsured people is to raise everybody's premiums, not just when they get sick, if they get sick, but right now, in the aggregate. And Wickard and Raich tell us we should look at the aggregate. And the aggregate of all these uninsured people are increasing the normal family premium, Congress says, by $1,000 a year. Those people are in commerce. They're making decisions that are affecting the price that everybody pays for this service.
Justice Kagan, again, with all due respect, I don't think that's a limiting principle. My unwillingness to buy an electric car is forcing up the price of an electric car. If only more people demanded electric car, there'd be economies of scale
Now, this
and the
is very
price would
different,
go
Mr.
down.
Clement, and it's different because of the nature of the health care service, that you are entitled to health care when you go to an emergency room, when you go to a doctor, even if you can't pay for it. So the difference between your hypotheticals and the real case is the problem of uncompensated care,
Well,
which
Justice Kagan, first of all, I do think this is not the only place where there's uncompensated care. If I don't buy a car and somebody goes on welfare, I'm going to end up paying for that as well. But let me also say that there's a real disconnect then between that focus on what makes this different and the statute that Congress passed. If all we were concerned about is the cost sharing that took place because of uncompensated care in emergency rooms, presumably we'd have before us a statute that only addressed emergency care and catastrophic insurance coverage. But it covers everything, soup to nuts, and all sorts of other things. And that gets at the idea that there's two kinds of cost shifting that are going on here. One is the concern about emergency care and that somehow somebody who gets sick is going to shift costs back to other policy areas, but holders. But there's a much bigger cost shifting going on here, and that's the cost shifting that goes on when you force healthy people into an insurance market precisely because they're healthy, precisely because they're not likely to go to the emergency room, precisely because they're not likely to use the insurance they're forced to buy in the health care insurance. That creates a huge windfall. It lowers the price of premiums. And again, this isn't just some lawyer up here telling you that's what it does and trying to second-guess the congressional economic decisions. This is Congress's findings. Findings I on page 43A of the appendix to the government.
Right, but all that sounds like you're debating the merits of the bill. You asked, really, for limiting principles so we don't get into a matter that I think has nothing to do with this case, broccoli, okay? And the limiting principles, you've heard three. First, the Solicitor General came up with a couple joined, very narrow ones. You've seen in Lopez this court say that Congress cannot get into purely local affairs, particularly where they're non-commercial. And, of course, the greatest limiting principle of all, which not too many accept, so I'm not going to emphasize that, is the limiting principle derived from the fact that members of Congress are elected from states and that 95% of the law of the United States is state law. That is a principle, though enforced by the legislature. The other two are principles, one written into Lopez and one you just heard. It seems to me all of those eliminate the broccoli possibility, and none of them eliminates the possibility that we're trying to take the 40 million people who do have the medical costs, who do affect interstate commerce, and provide a system that you may like or not like.
Well, Justice Breyer, let me take them in turn.
That's where we are in limiting principles.
Let me take them in turn. I would encourage this Court not to Garcia-ize the Commerce Clause and just simply say it's up to Congress to police the Commerce Clause. So I don't think that is a limiting principle. Second of all—
That's exactly what Justice Marshall said in Gibbons. He said that it is the power to regulate. The power, like all others vested in Congress, is complete in itself, may be exercised to its utmost extent, and acknowledges no limitations other than those prescribed in the Constitution. But there is no conscription in the set forth in the Constitution with respect to regulating commerce.
I agree 100%, and I think that was the Chief Justice's point, which was once you open the door to compelling people into commerce based on the narrow rationales that exist in this industry, you are not going to be able to stop that process.
I would like to hear you address Justice Breyer's other two.
Well, the other two principles are Lopez, and this case really is not— Lopez is a limit on the affirmative exercise of people who are already in commerce. The question is there any other limit to people who aren't in commerce? And so I think this is the case that really asks that question. And then the first point, which was, I take it to be the Solicitor General's point, is with all due respect simply a description of the insurance market. It's not a limiting principle, because the justification for why this is a valid regulation of commerce is in no way limited to this market. It simply says these are economic decisions. They have effect on other people. My failure to purchase in this market has a direct effect on others who are already in the market. That's true of virtually every other market under the sun.
And now maybe return to Justice Sotomayor's question.
I'd be delighted to, which is, you're absolutely right. Once you're in the commerce power, this Court's not going to police that subject maybe to the Lopez limit. And that's exactly why I think it's very important for this Court to think seriously about taking an unprecedented step of saying that the commerce power not only includes the power to regulate, prescribe the rule by which commerce is governed, the rule of Gibbons against Ogden, but to go further and say it's not just prescribing the rule for commerce that exists, but it is the power to compel people to enter into commerce in the first place. I'd like to say two very brief things about the taxing power, if I could. There are lots of reasons why this isn't a tax. It wasn't denominated a tax. It's not structured as a tax. If it's any tax at all, though, it is a direct tax. Article 1, Section 9, Clause 4, the framers would have had no doubt that a tax on not having something is not an excise tax, but a forbidden direct tax. That's one more reason why this is not proper legislation.